I was in the middle of putting together my thoughts on where the Resident Evil series has gone and what makes a game feel like Resident Evil, when two of my passions unexpectedly collided. The director of a low-budget, Dutch-produced English-language horror movie from 2013 stepped up to claim Capcom was guilty of, quote, creative abuse. He said on LinkedIn and in interviews with eager gaming outlets that Capcom had copied a scene from his movie, and more generally aped the design of his propeller head character from that movie. Now, the director in question, Richard Raphurst, must have signed some pretty bad contracts to get his movie financed. He produced, co-wrote, directed, and designed the creatures for 2013's Frankenstein's Army. But in interviews, he's claimed that he does not expect any royalties out of this dispute, apparently because MPI Media Group owns the rights to his movie. Still, he's raised an interesting point that, to me, highlights the unhealthy relationship between the reality of creating art, artists' expectations, and copyright law. I therefore can't stop myself from giving out another free lesson in copyright law to compare these two works and ask the fundamental question, who's right here? So, once again, I have to warn you that nothing I say in this video is legal advice. I also need to stress that I have never litigated a copyright infringement claim, and my interest and any expertise is entirely based on academic discussions and theory, and not the practicalities of litigation. When it comes to American law, there is very much a distinction between what an experienced lawyer can tell you about your chances of success in a specific given lawsuit, and what an academic can tell you about the history and theory underlying legal doctrines. So I'm only talking theory here, and specifically discussing the theory behind United States copyright law. With that out of the way, I'm going to explain why, in Capcom's shoes, I would absolutely never acknowledge anyone on the Resident Evil Village team was inspired by or had ever seen Frankenstein's Army, unless forced to by a court. I want to also briefly touch on why I think this is terrible for our society, and leads to shitty situations like this, where artists must fear litigation whenever they acknowledge their sources of inspiration, because we've so badly blurred the line as to what copyright law protects and to what constitutes infringement. But in order to get to all that, I need to lay out a few concepts inherent to United States copyright litigation, and of course the cases that illustrate those concepts. So, if you need a quick refresher on what intellectual property law is, I've got a video on that. For today, we're just focusing on copyrights, though. A copyright is a specific set of rights in something that you create. The broadest definition I can possibly give is that copyrights give people an exclusive right to copy their own creative works, and creators can therefore sue others who copy their works without permission. Copy, in this case, doesn't necessarily mean imitate or draw inspiration from, but instead means literally copying the creative elements of that work. I know, this is already heady stuff, and we haven't even defined the very first term, but I think it will help to get into a specific concept in copyright law called the idea-expression dichotomy. You see, most American judges have agreed that an idea can't be copyrighted, but expression of that idea can be. So, for example, in 1879, the US Supreme Court decided that Charles Selden's copyright in a book he'd written about a, quote, peculiar system of bookkeeping did not give him the legal right to prevent others from using his bookkeeping system, or give him the right to prevent others from copying blank account books that he had created and published within that book. In other words, Selden's copyright prevented people from copying his exact written explanation of his system, but it did not prevent people from learning his ideas and applying them. Applying similar logic, Wizards of the Coast can sue someone for publishing an exact copy of their books explaining the Dungeons & Dragons role-playing system, but they can't sue someone for publishing a book that explains and organizes the rules of that system in some different way. Very sensible, right? Maybe. It turns out this line can be very hard to draw. Turns out not everyone even agrees on what an idea is. Courts have tried time and time again to figure out how much of an artistic work is protected expression and how much of that work is merely something that's necessary to get to or explain that idea. So for example, we can all agree that deciding to use a whiteboard in this video is a choice I made in creating this video. But does that make the use of a whiteboard in a video a protected, copyrighted element? Or is the use of the whiteboard a necessary component of an educational video? In 2005, the New York District Court confronted the question of whether a jury could reasonably decide that Coors Brewing Company had unlawfully copied Jonathan Mannion's photograph of Kevin Garnett by creating a new photograph with a new model who posed similarly and wore similar clothing and, according to the court, bling bling. The court genuinely struggled with distinguishing idea from expression there, and noted, quote, "It is not clear that there is any real distinction between the idea in a work of art and its expression. An artist's idea, among other things, is to depict a particular subject in a particular way." The court first discussed the many ways in which photographs exhibit creative discretion that qualifies for copyright protection, including the choice or creation of a subject to photograph, the timing of the picture, and the angle, lens, aperture, and so on used by the photographer. Ultimately, the judge could not decide whether the similar photograph was merely copying Mannion's ideas or copying his expression. And so that judge left it to a jury to decide whether copyright infringement had occurred. Yes, that's right. Judges get too confused and can't draw the distinction between what is and isn't copyrighted, so they instead leave it to a jury of 12 random people who have so few strong opinions that they didn't even manage to get excluded from a jury. It turns out that's pretty much how every copyright case goes. Now, part of this is because technology and expression have changed so much since copyright was first conceived. Since the founding of our country, we've expanded copyright to include photographs, sound recordings, textile patterns, architecture, moving pictures, and even software, including video games. To my mind, the most egregious expansion of copyright hasn't even been connected to technology. Somewhere along the line, we introduced the concept of copywriting a character. Some of the most famous examples of character copyright claims include a holding that the character of Rocky Balboa was protected by copyright, and a ruling that Neil Gaiman co-owned the copyrighted characters of Medieval Spawn and Count Nicholas Cogliostro when he wrote the script for Spawn issue number 9. In the Neil Gaiman case in particular, the court ruled that Cogliostro's age, obviously phony title of Count, what he knows and says, his name, and his faintly mosaic facial features combined to create a distinctive character. No more is required for a character copyright. To me, that raises some troubling questions. It certainly doesn't help that jurors are given a very broad discretion to determine whether a copyright has been infringed. In general, jurors in these cases don't have to decide whether a plaintiff has proven his case beyond a reasonable doubt. That is the standard for a criminal case. In these cases, they only have to decide whether it's more likely than not that the infringement occurred. In other words, they just have to decide there's slightly better than a random coin flip chance that the defendant unlawfully copied the plaintiff's work. You'll notice I said the plaintiff needs to prove access. If you're thinking that through, you may realize no one needs to ever prove a defendant actually saw or heard or smelled or felt the copyrighted work in order to prove infringement. In fact, a judge went so far as to find that George Harrison unconsciously committed copyright infringement when writing My Sweet Lord, because it was such an exact copy of He's So Fine by Roger Mack. However, it's quite a bit easier to win a copyright case if you can prove the defendant actually knows of the copyrighted work. So that brings us all the way back to where I started, Resident Evil and Frankenstein's Army. While people have pointed out a couple or few character designs that seem to border on each other, I'm going to start out by examining Richard Ropehurst's claim that the boss fight scene with Sturm is a direct ripoff of his propeller head scene. Specifically, in an interview with Eurogamer, Raphurst said, quote, "It's just the same scenes as in my movie, except that in my movie you have to cut loose the fuel tubes. That's the only thing that is missing. But the whole thing is getting into flames, and then it explodes, and then the way it rotates through the camera, it's all the same, really. Even the environments, the whole color palette, it looks like an animatic for my movie. So what can we make of those claims? Well, skipping over the question of access for now, if MPI Media Group sued for copyright infringement, could a judge say as a matter of law that this fight in a video game and scene from a movie are substantially similar or not, as a matter of law? Raphurst himself points out some undeniable similarities. Both scenes take place in a dimly lit, rundown industrial setting, and in both scenes the audience has a first-person perspective on an attack by a creature with a turboprop engine grafted to its body. In both scenes, that creature eventually catches fire, and both creatures do explode. Is the color palette really the same? Is the environment really the same? No, but I don't think a judge is likely to say they're not similar. But how much does context really matter here? Is the scene really similar when one is a scene in a movie about a group of communist soldiers being attacked in a madman's lair in World War II, while the other is a scene where a player controls an American character trying to rescue his daughter from a madman in a haunted European village? Is it significant that a player defeats that creature by shooting it in a big glowing weak point on its back instead of by cutting a single tube on its head? When I'm looking at this, I think there's no question that they are similar. But I think I could be convinced either way on the question of whether they're so similar that Resident Evil scene is necessarily a copy of Raphurst's movie scene. That question is almost surely one a jury would have to answer if someone took it to court. And I mentioned that you can own a copyright in a character. That would seem, of course, to include a visual character design, including the designs for these Halloween creatures. Looking at least a couple of these side-by-sides, we can see that Propellerhead, Matchstick Man, and this Hammerhead shark-looking fellow all share some similarities with Sturm, Sol.Ein, and Sol.Jet. But concept art for Sol.Jet claims that the RE team was inspired by the horseshoe crab. Curiously, Raphurst's design has crab-like pincers for hands, while Resident Evil's has drills. Could a jury infer that Resident Evil's designs weren't inspired just by horseshoe crabs, but by seeing a creature like Raphurst's with crab claws and a crab-like head? What would a jury think about the fact that Sturm was called Propeller Man during development? Is that all just a bit too similar to Raphurst's propeller head? However, the counterpoint in this case boils down to a question of originality, genericness, and a little copyright doctrine called savoir-faire, a doctrine Capcom is all too familiar with. So let's travel back, shall we? To 1993, when Capcom got a little lesson in copyright law, courtesy of a developer named Data East. Data East released a nifty little game called Fighter's History, which Capcom immediately jumped down the throat of, claiming that it infringed their copyright in Street Fighter II. Data East pointed out that Capcom didn't invent fighting games, and that a 1984 game called Karate Champ originated many of the tropes that Capcom claimed were copied from Street Fighter II. While there was, quote, strong evidence that Data East, quote, set out to copy Street Fighter's success, the court ultimately decided that the copied elements were not protected from copying because they were savoir-faire, or elements which are customary to a genre. Capcom set about inventing a whole new set of savoir-faire for the genre of survival horror shortly afterward, introducing Resident Evil and all its quirky eccentricities in 1996. So, are the similarities between Raphurst's and Resident Evil's designs only explainable as direct copying of his work? Or is there perhaps some earlier work of horror both works might be referencing? Well, it might not help Raphurst's case that he drew up literally dozens, maybe hundreds of iterations of his characters before even picking which ones to turn into costumes. It also might not help that he said this.
Tekenen met tekenen is voor mij zo vanzelfsprekend dat ik er geen voldoening uit haal. Weet je, er zit geen uitdaging in. Ik gebruik voortdurend dezelfde middelen. Deze zombie is dezelfde als die. Alleen deze heeft de kap van die en een ander masker. Die is dezelfde als die, maar dan met zijn hoofd. Ik maak een paar basisontwerpen en ik zorg ervoor dat ze voortdurend gerecycled kunnen worden.
That seems like kind of a different attitude than 8 or 9 years later when he told Eurogamer, quote, "It's so difficult to come up with a great design. It's not just that ideas are floating around that you can grab, it's actually hard labor," end quote. So, anyway, to answer that question of what elements might be original and what might just be part of the genre, we have to go all the way back to the explicit reference point for both movie and game, Frankenstein. You all know Mary Shelley's titular character, Frankenstein. He cobbled together a new man made out of bits and pieces of old dead people, and then he gave it life, inspiring a whole subgenre of horror that we think of today as body horror. Although American audiences probably think about David Cronenberg before anything else, a definite inspiration for Moreau, the genre is probably more familiar to Japanese audiences through classic films like Akira and the Tetsuo series, as well as the slightly more modern works of Junji Ito. Junji Ito himself produced one of the most faithful adaptations of the Frankenstein novel I've ever seen, and if you want the substance of the novel without all that pesky reading, I can't recommend it enough. So, with that additional context, is it any easier to say whether Capcom committed copyright infringement with their character designs here? Or did both creators rip off Tetsuo, or find shared public domain inspiration from Mary Shelley's Frankenstein? Well, remember how I started this video saying Capcom shouldn't ever talk about it? That's because their defenses become much weaker if the works are not only similar, but also admittedly inspired by Rapphurst's film. If a jury were told that Capcom's character designers saw Frankenstein's army and were inspired by those creature designs, it's a lot harder for them to argue that they didn't copy any of that work's original copyrighted elements. After all, what is inspiration but taking someone else's idea and running with it? Frankenstein, Lee. An artist opens themselves up to threats of lawsuits and demands for royalty payments anytime they admit their inspirations, because of how open-ended the test for copyright infringement is. Yes, you can't copyright an idea, but, as we previously noted, quote, "It is not clear that there is any real distinction between the idea in a work of art and its expression." Copyright litigation in the US is incredibly expensive because copyright lawyers and the experts they hire are themselves incredibly expensive. If you have a 50-50 chance or worse of being held guilty in copyright infringement, it always makes more sense to pay out some amount of money to make it go away, or else face the significant chance of spinning into a financial death spiral, completely out of your control, when you're hit with a multi-million-dollar judgment on top of all those legal fees you've already paid. While denying your inspiration doesn't always work, let us not forget George Harrison and his unconscious infringement, it certainly improves your odds of defending against claims of copyright infringement to deny your inspiration. In my opinion, this legal landscape directly creates situations like the one here, where a creator is clearly inspired by another's work, especially within a genre, but really shouldn't speak up about it for fear of being pumped for money. The line between taking someone's idea and illegal copying is simply unguessable in most situations. I personally think it's almost impossible that Capcom's creators didn't take some ideas from Frankenstein's army. The movie definitely came out in Japan, and while both works reference Frankenstein as inspiration, there's very little of Mary Shelley's original work to be found in the idea of grafting a plane propeller to a man's face. Nonetheless, Resident Evil's version of these concepts skews a lot closer to the style of the Tetsuo movies in a lot of cases. And at the end of the day, Capcom did put a propeller in a man's face decades before Rapphurst. I think Rapphurst deserves some credit for his ideas, but I also don't think he's earned the right to demand money every time someone slaps a carburetor on a torso and calls it a monster. US copyright law has become an unpredictable mess, and that's before even getting into other vague legal doctrines such as fair use, which whole sections of the economy, YouTube, rely on precariously for their very existence. When it comes to protecting elements of characters, for example, where does it end? Did Abigail Thorne infringe a DC Comics copyright when she wore a green jacket, hat, and purple gloves in her latest video? And ask the audience to riddle her this? But, of course, now that you've been educated, feel free to let me know I'm a big exaggerating baby down in the comments. This is a topic I love talking about, even if it infuriates me that so much of the world revolves around inherently subjective and maddening distinctions. Is copyright law just people shouting, "Quit copying me!" at each other on the playground until one of them hands over millions of dollars to make it stop? Or is it a rational, principled system, justly generating more than a third of US GDP? I really appreciate you putting up with this law school lecture, and I hope it was as illuminating as a flaming propeller head in a dimly lit warehouse.